Kim, did you see they sent that email back and saying we all have a super zone? They're making every division of the super zone staggered over a 2-year period. I'm just waiting for the computer to block the crash.
That is super soon.
So right now in this program, we have the Jazz audio recording system, which is right there, see it, right? So that's what runs it, records everything, and we maintain the court records internally. And if you request a transcript or recorder accesses the system, the videos, it makes the transcript. Super Zone gets rid of this because you have to pay for the people that maintain the system. Super Zone is where instead of having this system, they just equip the courtroom with microphones so that everything's recorded on Zoom technology.
It's the Zoom.
It's
right back.
Okay, I just can't see that. But I guess Jazz took a lot of business too. I just don't trust based technology. It's like, where is it? What if somebody gets it? And our internet is down all the time. Like our network isn't very stable. I always joke that the network is being held together by an orange extension cord behind the back of the building in the attic. So, I just like, they try to make me get to this one. I was like, no, we don't want it. Yeah.
That's one of my.
I just don't trust it. Following case number 240113388CH, LaFleur versus the city of Detroit. This matter is before the first day of the defendant's motion for summary disposition. Your appearance is the record, please.
Patrick Mason, Your Honor, on behalf of Virginia for plaintiff and
Eric Gabo, swearing on behalf of the defendant, plaintiff, city of Detroit.
This is your motion.
Yes, Your Honor, you may recall this case. We were in front of the court back this fall at a settlement conference, trying to hammer out.
Was I in the other courtroom then while they were renovating?
I believe so, yes.
Yeah, that one we had super.
Yeah. And
Anyway,
I thought we were coming close, but we could not resolve it. That's why we're here now with a motion. Your Honor, this case involves the city of Detroit's demolition of a severely fire damaged house located at 79 Westminster. Our position is that we cannot be liable for a taking claim or adverse condemnation because case law says that municipality isn't liable where they are conducting a demolition to abate a nuisance. We feel that there's really a nuisance here based on the reported photographs showing the damage.
is the issue nuisance or the structural integrity of the building creating safety?
The issue is, the plaintiff claims that there's a fact issue regarding whether or not the demolition was required based on the condition of the building. Our position is that we supported that with an opinion by a trained inspector who has extensive training regarding issues of this type, regarding structural integrity, dangerous buildings.
What about the affidavit of Christopher J. Smith, who said that it was, and I believe it's he said in his affidavit, following my inspection of the site at 79 Westminster, I prepared a report which is attached to Exhibit 1. In my report, I stated that at the time of this inspection, no part of the structure appeared to be in danger of falling onto a public way. The structure is damaged to the point that it is not able to be occupied until proper repairs have been made. In my report, I merely indicated that if a portion of the structure were to collapse, the building was not likely to fall onto a public way. Not that no portion of the building is likely to collapse, which was beyond my scope of my duties.
Yes, Your Honor, I think that that portion that you quoted is important because it shows the narrow focus of what Mr. Smith was reporting. He works for the Fire Marshal Division, which, first of all, deals primarily with fire safety issues, not with structural integrity.
It's done by a different department,
Yes, BC Buildings Safety
I'm saying
Engineering.
right,
Well,
BC.
we call it BC.
BCD.
Yes, the Buildings Safety Engineering and Environmental Department. So the only thing that he was really talking about was if it were to fall, was it close enough to a public way, sidewalk, a street, or an alley? And the reason why that's something he's concerned about is because the Fire Marshal Division primarily deals with commercial structures, not houses. In fact, I was surprised that they even went out there. Commercial structures are often built right up on a sidewalk or right next to a street. And so if they are going to fall down, there can be danger that they're going to fall into a public way. The point that we made in our supplemental brief is that houses are different. They are always set back from the street. That's pursuant to the local code. So no matter what happens to a house, it's going to fall down. It's not likely to fall all the way out to a street or a sidewalk or an alley. So if the rule is that it cannot be sufficiently dangerous to require demolition unless it's going to fall in a public right of way, then we would never have any demolitions of houses because they're always set back from the street. And in fact, one of the cases that we cited, the asset management case, I think is a good example of this. We attached photographs. That was the case just last year, involving the very same issue. In fact, it was brought by Plan's original counsel. It's the same kind of situation involving a house that had been damaged by fire. And the same argument was made that there's a fact issue here, whether it be torn down. The federal court in that case said there's not a factual issue here. Just looking at the photographs, there were freestanding walls and such. So that's an example of a similar house that if it were to fall, would not fall on the street.
Are you saying, I just want to make sure I'm following what you're saying. Are you telling me that these pictures in Exhibit C to your supplemental brief are not the plaintiff's house, but a different house?
No, they're a different house. I'm just giving the example that the court found there was no fact issue there, even though I think you can see in the background that the street is pretty far back. So they would not have fallen on the street or the sidewalk either. But the court
Let me
found.
pull these pictures up so we can make sure we're talking about the same.
Pardon me?
I said, let me pull these pictures up on the
Okay.
screen behind you, so we can make sure, I make sure I'm not confused when we're talking about the same pictures. Are these pictures what you refer?
Correct. Those are the pictures that involve the house in the asset management case.
Okay, not the house in
No.
this case.
The pictures of the house in this case were attached to our original motion as Exhibit A.
Okay, I didn't mean to throw you off, I just wanted to
No,
make sure that I was looking at the right pictures that you were referring to.
correct. So again, the point of the Mr. Smith's affidavit is doesn't really contradict any of the statements and conclusions by BC who are trained to deal with these issues. And I would also point out that it was not only the inspector, Mr. Perry, that reached that conclusion, but he has a supervisor that concluded that, and then this was also reviewed by the head of the entire BC department, David Bell, all of whom have training in structural integrity of buildings, dangerous buildings, and that kind of thing. They all concluded that this was sufficiently dangerous that they needed to demolish it.
On an emergent basis.
Correct.
Not just demolish it, but emergency demolition,
Correct.
which is an important distinction.
Yes, it is. The plaintiff claims that there is a fact issue, but the problem with plaintiff's argument is that they don't really have any evidence, admissible evidence that contradicts the city's position. They submitted an affidavit where the plaintiff says that she was told by some third persons that they could rebuild the house on an existing foundation. The problem with that is it doesn't contradict the argument that it is dangerous, that it needed to come down. In fact, that very argument was rejected in another case, Sachs versus City. Which we cited. And there are multiple other cases that we've cited where similar arguments that we dispute that it is sufficiently dangerous to require demolition. Of course, it's found that doesn't create a fact issue to summary disposition. So we need more than that, and they haven't done that here. They made some other arguments. For example, they say that this building was vacant, so it wasn't sufficiently dangerous. But Your Honor, I would say every house that is going to be demolished, as emergency demolition is vacant. But that's the rule. Again, there would never be demolitions. They said that you could keep out signs out front. In fact, there were some. Again, the problem is people ignore those. Scrappers go in, children are curious, homeless people go in. So just putting a sign out front doesn't mean that no one's going to go in. They said that, well, we could have put a fence around it. Again, people ignore those fences. And there's a case right on point, Orient Township versus Burnett Corporation. The court said, that's not going to eliminate the danger, just put the fence around it. The plaintiffs also claimed that we should have left the foundation in place, allow them to build top of it. That's part of their idea. There are several reasons why that argument is not persuasive. First is that this isn't how demolitions of dangerous buildings take place. We've cited the Detroit Code, which says that everything has to do with the foundation, the walls, every part of that building. And that's consistent with other codes around the country. Other states can have the same kind of regulations. And once you take something down as a dangerous building, it's all got to go, because you can't just leave part of it. And part of the reason is that leaving the foundation in place itself would have been a danger. Because you can't have an open thing, you know, it could have been, that could have been crumbling itself. You know, so it goes, here's over the edge of the foundation, wall breaks, they fall down. And we cited an example. This happened in my own neighborhood. In the Woodbridge neighborhood in Detroit, there was a construction site with a foundation pit. Just sitting there, and it probably had a fence around it, but a kid fell into that, and it filled with water. And man tried to save him, but he died. So you wouldn't think that this is necessarily a dangerous thing to have a hole in the ground. But it is, and that's why we have these regulations that say, once you start that process, you've got to remove the building. The final reason why we don't believe that argument would make sense is that, as a practical matter, I don't know how you would enforce it. If the rule is you can only tear down a portion of the building that's actually damaged, where does that stop? Do you have to look at every wall, every window, every floor? You can't just, and again, you know, they're using massive equipment to do this. How would you preserve one part of the building and take down just the other part? It's unworkable. So I don't know how you would do that. In fact, I guess the other point too is that the insurance companies recognize this. In fact, I'm not sure if the policy in this case said that, but They specifically recognize that when they're paying out claims on demolitions, a portion of that will be to pay for undamaged portions of the building that are torn down because of building renovations. So I don't believe that the argument would make sense. I guess the only other point I would raise is that they have cited some cases. A claim established a proposition that we can only tear down part of a building only as much as is necessary to abate a nuisance. But the cases they cite are not demolition cases. They're not even closer to the same. They involve denial of licenses and things like that. So I don't think that the cases that they cited contradict the cases that we've cited that establish the proposition. When we tear down a building to abate a nuisance, it's not an inverse condemnation. If they want to create a fact issue, they need to have something more than just a statement that someone told them they could build on this foundation. I don't think anything.
Just from the phone, and this is who that is arguing too.
Thank you, Your Honor. As you know, today's the date time set for the defendant's motion for summary disposition. Our position is that summary disposition is wholly inappropriate where there are questions of fact that remain. And those questions being whether this property truly poses an actual and immediate danger requiring total demolition. To that point, Brother Counsel indicates that how would we know when we can do this or do that? In every case, we would never be able to demolish, but that's not our position. Our position is that there's a balancing test that is required to be adhered to. And the question becomes whether that destructive safety measure that was taken was actually necessary to protect the public, whether there was a less restrictive means available. And so those questions of fact are questions that we give for a jury to decide. Some of which, Your Honor, we want to point out that Brother Counsel's case in chief rests on an ordinance in the city where it says that the necessary work to abate a dangerous condition may be done by the city where there is a dangerous condition. However, a section just before that ordinance, there's another ordinance that says that the fire marshal can order people to vacate. That's a complete separate section. So they're making a distinction between a scenario where you must do the necessary work to abate the conditions for the people's public versus a scenario where you can just order people to vacate. So there's clearly the legislator intended for the difference. And our position is that that's why Christopher Smith comes in and says that the fire marshal for the city of Detroit or the fire prevention expert for the city of Detroit states that this property would not harm anyone were it to fall. The difference in that ordinance being one section allowing you to abate condition, another asking people to vacate, is where the falling itself, the collapse itself would be the danger, not necessarily someone being in the building against the fencing that may have been provided. That's not what's at question. So our position is that there's a balancing test that must be adhered to, and the greater the nuisance, the greater measures that may be taken. If we were to take Brother Counsel's position, just logical, and every building is a nuisance. Every building could be a danger. Anyone can climb on the roof and jump off. So we're talking about a protected liberty here, the right to property. Remember, it's an enumerated amendment. So for that to be the case, it has to be strictly adhered to. The position has to be strictly adhered to. In fact, in Lucas v. South Carolina, Justice Scalia, the majority opinion, imposed a stricter standard where there is a taking, even where it's for the public good. It must be shown. Justice Scalia indicated that the public good can always be justified depending on the perspective. So he did impose a stricter, narrower standard going forward. Furthermore, Your Honor, in this very city, besides the Sachs versus City of Detroit case, I have to look about Sachs. Flawed man as he were, he had a building where bricks were falling off of that building and landing on cars. Even in that scenario where the collapse was the actual danger itself, Ralph Sachs was given 2 years notice before this building went down. A brick fell on a house, a brick fell on a car that was properly parked in January of 2012. The building came down in July of 2013, a year and a half later. Yeah, so we believe that Christopher Smith's affidavit supports the position that the collapse itself had to be what the danger was. Furthermore, where the public's good is advanced at the expenditure of a private citizen, that citizen must be compensated for his loss. That's a maximum that's defined in Miller Rose and DNR, and it's furthered in other cases as well. Just because of the public good is advanced, we don't want to stop the public good from being advanced, but that homeowner must be compensated for his loss. He cannot be the one who is bearing the burden of that cost. And furthermore, Judge, when you're considering the balancing test that must take place, a part of that balancing test is what measures were taken to provide notice to the plaintiff. And we have case law, Dow v. Smith, that says that for there's a significant interest at stake, in this case being ownership of property, then the opportunity for a hearing must be made available. In that case, publication was not considered enough. We would argue that the notice here was much less than that. The notice here was mailing that was done to the house that had already been burnt down. That mailing was never going to be received. All right. And part of the case law that we have cited and the opportunity to be heard includes a reasonably calculated, under all the circumstances, opportunity to receive notice. I don't think coming something to a burnt down house is reasonable whatsoever, nor is posted on that house. Particularly, there may be instances where it is, particularly when you had opportunity, you had her phone number, your people, fire marshal and so forth, contacted her, met with her on multiple occasions at the house, outside of the house, were able to reach her. She's not hard to reach. There is case law on that as well. In fact, there's case law in Green v. Lindsay where notices that were tacked on a door of a place that wasn't burnt down were not sufficient, where it is known that those notices have been from time to time removed. So there are instances where there's been less damage, there's been less restricted means. Further anecdotal evidence, Your Honor, oddly enough, in the city of Macomb, right next to the county court's building, the county court circuit court, a building is currently falling. There's bricks falling. What did they do? They erected a 2-foot tall mesh fence. It has been there for over 45 days. You drive by there right now. The bricks are falling. There's a fence that keeps people away from that perimeter. Can someone cross that fence? Absolutely, you step right over it. But that doesn't give a blank check to the city to take any action they want and guise it as public good. In fact, Justice Scalia completely obliterated that train of thought in the South Carolina, specifically indicated that there is no blank check for that, and public good can always be the label that you put on something and just take property for anyone you want. So the public good would be actually protecting our right to property, right to property, which is, like I said, an enumerated right. Furthermore, Your Honor, their counterclaim for demolition cost is absolutely not right for summary disposition. It's something that cannot be decided on a motion for summary disposition because, again, the scope of the demolition must match the necessity to abate the hazard. That's cited in Jerry. This is a Supreme Court case, and if the process is constitutionally effective, the cost shift is not shift to the plaintiff. So there's this case is littered with questions of fact that need to be determined by a jury or by a trier of fact. The insurance company in this case, when he speaks on there not being proof that was advanced, there was an affidavit. We also had estimates that were provided after the house went down. Once that foundation was taken down, the insurance company had to provide a new architect, a new design, new plans, a new foundation. All those costs were not going to be covered because insurance only covers the damage that was caused by the fire, not the damage that was caused by the city. In other words, if the insurance company were to infleet into this case, they'd be bringing forward the same motion against the city for improper demolition that cost them more than they needed to pay off. And then in addition, Your Honor, instead of a 2-year plan, it took 3 years now. And the insurance company did not have to pay for that extra year because the fire did not cause this to go from a 2-year bill to a 3-year bill. During that period of time, the plaintiff was displaced and suffered all sorts of damages, as you can imagine, Your Honor, mental pain and suffering, costs, and so forth, health problems. And so, for those reasons, we feel like this is absolutely not the time for a summary disposition. This case needs to be heard by a trial.
Your Honor, plaintiff continues to argue that there's some kind of balancing test involved in this situation, but there's no case law that establishes that in a is a physical taking of the demolition. If it is required to be demolished, regulations, again, Detroit is not alone in this, they require that the entire structure must be taken down, half the site has to be cleared, because you can't leave half of it there. That in itself is a danger. So, these cases that he's citing, I'm sorry, but they just don't find this context. He talks about notice, and actually you mentioned early on that there's a difference between demolitions and emergency demolitions. Emergency demolitions do not require prior notice. There's case law well established on that. But even if they did, there was notice provided in this case. There was, the day after it, there was a posting brightly on the front door. There was a notice mailed out to the plaintiff. And that didn't come back as not deliverable because the plaintiff was having the mail say that the post office, and she testified in the deposition that she could have gone down and picked that up. So, in fact, she did get a notice. The reason she didn't take any action is because her insurance adjuster told her they're not going to tear this down anytime soon. So we gave her notice, posting it. Then by mailing the notice to her, then we went out again and posted it with a different posting. Then we put large signs in the front, bright yellow signs that said this demolition is imminent. So I'm not sure what other type of notice we could have done, especially given the fact that we're not required to provide any of this under constitutional purposes. But we did that. So I don't think there's a fact issue in terms of the adequacy of notice. There is, I think, again, we've cited in our brief, there's Supreme Court precedent, U.S. Supreme Court precedent, as well as the Sixth Circuit precedent, that posting is by itself constitutionally adequate to provide notice of a demolition. There have been cases where, yes, the only notice given was the posting and that flew off the house after a couple months or something. But that's not the case here. We have photographs showing that none of those notices ever came up. They're there on day one, they're there just before the demolition. So theoretically, there could be a problem if there was only one type of notice posting and that blew off at some point. But they haven't made that because it is true. It didn't happen according to the photographs that we have. I don't believe I have anything further.
It's his motion, so he gets the last word. So if you go again, then he has to go again. That's just not the way it works. But you all did it.
Thank you.
Who's next? Parties on Eden versus June. Good morning.
Good morning, Judge.
Good morning. Calling case number 2401-3059 Nathan James Eden versus William Deshaun Edler and Pure Auto Insurance Company. This matter is before the court today for a motion for summary disposition. Your appearances for the record, please.
Dennis Schmatz is going to be at the front. Judge, we don't have hearing on behalf of the defendant. Yes, so defendant filed this motion. There's two main arguments in this motion. So first, and both of these arguments are in relation to plaintiff's claims for services that it states are that were EQMD fields or EQMD services. So the two arguments are first, that EQMD does not provide services that are compensable under the No-Fault Act. So EQMD is a billing provider and they provide technology. They're a service that providers use to do their work, to accomplish the treatment. However, EQMD itself doesn't render any treatment. It can't, it's reaffirmed this many times in different courts across Michigan. And it knows that it has to say this because it's true, number one, and number two, they're not licensed as any sort of treatment provider, so they never get away with it. So they know, they say, all right, we are not a treatment provider. However, so the way that they typically claim these bills are through assignment. So they're a billing company, and then sometimes they'll get an assignment from the provider, and then they'll say, okay, well, we'll seek these benefits on your behalf. Here, so when we don't have any assignments, there's not, the EQMD doesn't have any services that is provided that are compensable. So here, there are no assignments showing that. So number one, EQMD itself can't provide anything that's compensable. It's not a treatment provider, it doesn't provide treatment. Number two, there's no assignment showing that anybody gave EQMD the right. Or number three, that somehow EQMD gave its right, that it inherited to plaintiff, who is the patient. So altogether, EQMD does not have anything that's compensable, therefore those claims must be dismissed. However, so the second part of this is, like I said before, EQMD provides these billing records and this they serve as billing services for providers. Here, the bills at issue are spine specialist Michigan bills. So let's go to the actual source of these services. Spine specialist Michigan. They have assignments where plaintiff has assigned away their rights to claim these benefits directly to spine specialist of Michigan. So we're also asking the court to dismiss these claims. One, we want the court to find that these claims are the real party interest in these claims are spine specialist Michigan. And next, we're asking the court to dismiss these claims because plaintiff doesn't have the right to seek these benefits. Now, attached to our these assignments, as plaintiff brought up in their response, there was 3 different pages of assignments. So there's one assignment that plaintiff attached to its response again, which is it has the under the letterhead of Lewis Madden. It says that basically it requests payment for these services as spine specialist, and then
You said that was attached?
so actually wrong one. So that you're right. That one was attached to mine. Sorry, the next one it is under Lewis Madden's header. Yes, this is attached to plaintiff's responsibility as well.
Hold on,
There was
hold on.
Okay.
Sorry.
There's one, there's an assignment that I attached. I don't think you have a piece from
No,
that.
it's attached to mine as well. I attached 3
Can
sort
you
of
guys
assignments.
stop talking,
Yes.
please? I said, hold on, and then, I don't, I'm not ready for you guys to talk. So give me a second, because I don't have what you're talking about. So I'm just trying to figure out what's going on, the figures that. I can't, give me just a second. My law clerk sent me the brief, but not the, so I hadn't seen it. So give me just a second. Which exhibit number are you talking about?
The assignments are attached to defendant's motion as exhibit number
I
4.
thought you were talking about.
Yes, and then
What was attached to the plaintiff's response?
one of the pages of the assignments. So we attached 3 pages of assignments as exhibit 4. One of those pages was attached to plaintiff's motion, and I'm
This
trying
is
to.
what I have.
Okay.
Michelle, if you're talking about something.
It's my exhibit number 6.
It's just the document to which you.
Yes, so this is the first one I want to refer to, and then there's one more that comes to me, I believe immediately after this one. So,
I just want to make sure we're looking at the same document.
no, I appreciate it, Your Honor. And it's important here because, I mean, we're talking about very specific contractual language. So plaintiff, focused in on this assignment, which on one part says that basically plaintiff assigns its right, to collect benefits to Radin. It also says, however, if Nathan Ely, wishes, so let me find it. Should I pursue litigation against my auto insurer here that I may, or my counsel may have the authority to collect any bills on my own behalf. So it kind of like assigns away the bills and then also says, but I still have the right to seek these bills myself. So that's the assignment. And I would admit, if this was the only assignment that we had, I don't know what the legal effect of assigning something and then immediately saying, but I actually also have the right to claim these benefits. I don't know what the effect of that alone would be. However, that's not the only assignment that we have. So there's another assignment that, and that's meant, yeah, and so there's another assignment that we have, and it's on my exhibit 4. It's the next page following exactly. And this is the more typical assignment of benefits. So this is just your typical, I assign, I request payment on my behalf, be paid spine for this. I understand that I am financially responsible. This says, this along with like that first document, these are more typical. Spine specialist has the right to seek these benefits. If you were to pay them directly. And I believe
Where
that,
are you,
see that,
I don't, what document are you referring to? Because I don't see it.
so I think all
Are
three,
your
yes.
exhibits attached separately? Did you file separate exhibits? Here they are. I found it.
Exhibit 4.
The exhibits were filed separately. The motion was filed on December 5th. The exhibits were filed on December 8th. So, the exhibits is not. Okay.
So the
You're
last
on number
page.
4.
Yes, and so the exhibit 4, and it's the last page of those exhibits. I assigned to spine specialists all no-fault benefits presently due or past incurred as a result of my accident. I assign my right to recover no-fault interest and attorney fees as it relates to the reimbursement of these bills. I'm not assigning any benefits. I understand that spine specialists may collect on its own behalf against my insurance. I grant spine specialists and or its attorneys permission to receive all benefits that are not limited to insurance claim files. So this is the more typical assignment. So we have this, so we have an assignment that says I assign you something, but I can also seek it myself. And then we have another more typical assignment that says here, I'm granting spine specialists my right to claim these benefits. And I believe that based on this assignment, that is clear and the language is consistent with how we normally see assignments. Plaintiff has assigned away his right to seek benefits for services provided by spine specialists. And as a result, plaintiff cannot seek those benefits because he's not the real party in interest in the suit.
So your argument is not the reasonable or necessariness of the services.
No, we
It's
haven't gotten
that,
there
it's
yet.
that they don't have any authority to pursue these bills as a result of the assignment.
That is correct. This has nothing to do with reasonableness or necessity. I understand that plaintiff also argued that there should be attorney fees awarded and the court should, we haven't gotten there yet. And the plaintiff rely on orders granted from this court in matters where there was default judgments. So we're a long ways away from that right now. Right now, we're just talking about whether plaintiff has the real party in interest to claim these benefits.
Judge, let me go backwards here. The assignment of rights that I attach to my exhibit 6 indicates that the plaintiff, which is Mr. Ely, who's in court on my there, has a right to sue for the unpaid bills. Also, ignores that one. Cites other assignment of rights that are not as broad in the language. But this language, I'll read it to you for the record. It's further expressly understood that should I pursue litigation against my auto insurance secure, I being my client, Mr. Ely, that I or my counsel, which is me, have authority to collect any bills owed to fine special in Michigan on their behalf. That's what we do. We sue. And we're entitled to collect any outstanding bills. Now, what we have here is just a blatant attempt by Qiana Insurance Company not to pay the correct benefits that are entitled here under the No Fault Act, 500.31071A. No fault statutes and laws, payment of allowable expenses and consisting of all charges incurred for reasonably necessary products, services, and accommodations to an injured party. MCL 500.3157 indicates that the services have to be lawfully rendered, which they were by a fine specialist in Michigan. Now, what I found really interesting was that counsel in his brief at page 6 ignores the fact that the Oakland County Circuit Court granted some of the items through summary disposition, but at page 6 of that court order, the court in Oakland County, which he relies on and ignored in this brief of law, indicates that it's been, the court, Oakland County has been provided with no authority indicating that No Fault Act prohibits a provider from billing for its charges through a separate entity as EQMD. And what was not attached to his brief is a second opinion by the Oakland County Circuit Court, which apparently he didn't see or didn't want to attach. That second opinion, which is not an opinion indicated, called it opinion in order granting claimant's motion for limited reconsideration. That second opinion, which is not attached to the brief, I had to locate it, indicates that EQMD, which is a pharmaceutical provider, could support, the judge up there says the fact that there are assignments could support plaintiff's assertion that there's a separate contract and intent for plaintiff, which is EQMD, to have their bills collected. But I attach that as my exhibit 3, the reconsideration order, which he did not attach. What I found really interesting there on my further research, this is a little looking for, but I found this court back in 2019 in the case of Jones and EQMD versus Living Mutual, case number 19-005341-NI, issued an order. You did, okay, 6-7 years ago, indicating that the title of your order is really quite appropriate. You issued an order finding unreasonable denial of EQMD's claim under MCL 500.31448. That was on January 19, 2021. You indicated Carrier's denial of EQMD's bill was unreasonable behavior. Should I say any more? You've already ruled on this issue. Then you issued another order, which took me a little while to get out to find out. On March 12, 2021, you issued a second opinion assessing the attorney fees and costs of $7,500 against Liberty Mutual Insurance Company for its unreasonable refusal to pay the no-fault benefits of EQMD. Should I say any more? Do you want me to continue? You already wrote on the subject, but they're wrong. But anyway, let's see the assignments. He attaches 4 assignments. What he is not emphasizing today is the one that says my client and I can sue for the EQMD benefits. That's my exhibit 6. Long and short of this, Your Honor, is that this is just a blatant attempt by Qiana Insurance Company to avoid its obligation to know that. What I would indicate is, as you indicated in that 2019 opinion,
what's the 2019 case was the 2021 hearing. But anyway,
Wait a minute, I know you're thinking it's correct, 2021. I hope it's still corrected, I'm sure it is. Having said that, you assessed $7,500 in attorney fees against Liberty Mutual. And you had to pay that's what I'm asking for today. Ask that you assess a penalty against secure insurance company for filing this frivolous motion, that you have them also pay the EQMB bill of $10,122. That's it.
Quick response. I'll just refer, one of the cases. So there's reference to, I think maybe a slight indication of some sort of hiding of the court of that motion for reconsideration, partial. If we look at that partial motion for reconsideration, that's attached to plaintiff's response. This actually furthers my point. So the reason that the court granted that limited reconsideration was because the court said we're wrong, actually. EQMB does possess assignments for these few claims. So because we were wrong, that we actually didn't notice these few assignments that the provider, that the plaintiff gave to EQMB, we're still keeping those ones that don't have an assignment for EQMB. Those are still dismissed. But the ones where we do have the assignment, for those, they are reinstated. So I suppose defendant could have attached that. However, I think it doesn't really change the fact and the argument that we have here, which is EQMB doesn't provide services. They're very clear on that, and they have to be the law because they're not licensed to provide services. Instead, they're basically a billing company that also have some back-end software that helps providers. Sometimes they seek benefits directly when they have assignments. Here, we don't have any evidence that there are any assignments. And either way, that would have only granted EQMB the right to bring these suits, not plaintiff ELAY. As of right now, these services, which were rendered by spine specialists, the plaintiff assigned away their rights to claim those benefits. And for those reasons, we asked the court to find that those claims, the ones that plaintiff alleges as provided by EQMB, are actually the real party in interest of those claims are spine specialists, and that they exist.
heard your arguments, but I just don't find it to be very persuasive because I'm going to tell you, I need to get right to the exact language. You look at the very language of the releases that you are attempting to rely on.
So you're gonna give me assignments.
Thank you for correcting me. It expressly, the assignments are invalid because they assign a right while reserving the right at the same time. It says expressly. And I'm referring to, this document is attached as an exhibit of both the plaintiff and the defendant. And it expressly says, it is further expressly understood that should I pursue litigation, a lawsuit against my auto insured group, that I or my counsel have authority to collect any bills owed to spine specialists of Michigan PC on their behalf. And I understand that the defendant is trying to rely on, and that's the portion of, I believe, Exhibit 4. And I understand that defendant is relying upon the language in the other portion of a different release that says, I understand. I'm sorry, I keep saying release. I don't know what's wrong with me today. Y'all know I won't be back to work for 3 weeks now, so my brain is still not used to working. But I understand that there is another signed release, signed assignment that appears to be executed by Mr. Ely that doesn't have that unequivocal language. But when there's ambiguity in these contracts, the equities don't provide, to me, doesn't favor the defendant. Not really, so don't interrupt me. I'm making my ruling right now. If you want to say something else, I'll give you a chance when I'm done, but please don't interrupt me. But I'm sure you must have something really important that you want to say. And I'll give you a chance to say it when I'm done. I'm just looking at these circumstances here. And I'm looking at everything in the light most favorable to the non-moving party. And under the circumstances, the argument here is twofold, as I understand it. Number one is that EQMD didn't really do anything, and they're not a medical provider, and they have no right to pursue any payment of any bills. But even if that's the case, the bills are still for services that were allegedly rendered to the plaintiff patient, who is still the plaintiff in this case. I just don't find your argument to be persuasive at all under any legal analysis of the facts here. And I don't think that you're entitled to the relief that you're seeking, so your motion is respectfully denied. There was something really important that you wanted to say, I'm glad you said it.
Yeah, so just for the record, I understand your ruling. I don't usually like argue after court's issued its ruling. So just the existence of one ineffective assignment has no bearing on an effective assignment.
Also, you just wanted to say something, you already said it one time.
Well,
Have a good day.
these are two separate,
That
yes,
concludes
thank you.
this matter.
Assess costs, it's your insurance company.
I know I've done it in the past, but not at this time, I'm not going to. I think he had a valid basis to pursue his motion, I don't think it was frivolous. I think under the circumstances, he had a valid legal argument to make, although I disagree with him, I'm not gonna assess him sanctions or costs.
Can I actually have,
Motion being frivolous.
can I have one more request, which is
What?
just that the court find that the, something, okay, so what we're worried about. No, you're
really, if I'm not mistaken.
Well, no, it's just that, that these services, that the services are the real party interest to bring these claims is plaintiff or spine specialist in some way.
I think the real party of interest is the plaintiff,
Okay.
he's the plaintiff, but he's pursuing payment of his bills
So-
that were the treatment from Dr. Red that was billed by EMQMD, that's all questions for some fact finder to sort out at a different time.
I only ask because sometimes EQMD after the fact will file suit and then they'll say, so can I have part of the order state that the real party interest is
The patient plaintiff.
the patient plaintiff?
That
Okay,
was
because
the
that
basis
will,
of my ruling, that
yes,
he did not assign anything away, there was no valid assignment.
thank you,
Okay,
thank you.
bye.
Before he files an order, can I review it?
Yeah.
Before he files it.
Of
You understand?
course.
We have a settlement conference.
You do? Y'all not gonna settle today, are you not after this ruling, y'all need to talk about it, don't you?
Yes.
So should we appear for a settlement conference or not?
I think you're gonna get another day. For the summer.
Thanks, Judge.
Who's next here?
Oh,
Who are these lawyers in the zone? Some lawyers just showed up in the zone. And then I think they're here on a motion for summary disposition. And if so, they need to be given another date because the sheriff is there. There's no more summary dispositions on Zoom.
I'll see you later. So I have one person that checked in on city to city. Is there,
Somebody's on Zoom on city to city. That's what I'm talking about.
I didn't know.
Is somebody here on city to city? And your opposing counsel is on Zoom?
Possibly? No idea.
Attorney Hayar,
Morning, Your Honor.
sir, what are you doing on Zoom? Let me turn you up, I can't hear you.
Sorry, Judge,
What are you doing on Zoom?
I thought the motion was on Zoom, Judge.
It's not, and your opposing counsel's been sitting here in court waiting for you for over an hour.
I apologize, Judge. Ali was, or from my office, has been on since 10 and he had to hop off. I just logged in.
I don't know what you're talking about. I can't even. Say that again.
Sorry, Judge. Ali from my office was on Zoom at 10, and he just asked me to hop on because he had to get off for a
That didn't help. No, I still don't know what he said.
He said Ali was on at 10 and then he had to log off for something else.
Well, the reason nobody paid attention to him when he logged onto the Zoom at 10 was because the notice of hearing clearly indicates that this motion is taking place in person, not on Zoom. So I don't know what to tell you, but I guess you guys are gonna have to get another date. And you'll have to explain why you shouldn't have to change opposing counsel's costs. You're sitting here and have to come back a second time. So, step into that. And Seth will hop on Zoom and figure out another day for you all to come for your motion for some disposition. Well, let me just give you a hint. Anything in this courtroom after 9:30 and beyond is in person. Step into that, Seth. So hang on the Zoom, Seth, she's coming back there, so Seth can try to get y'all another day. Who's next?
Understood.
Someone from First Johnson Homes, are you all ready?
Are you guys ready on the Dover hearing?
Yes, Your Honor.
Okay, get in position while I talk to these lawyers in the back, okay? That means
Good morning. Can you hear me?
Hey, Seth. Yep.
Okay. I have Lauren here. So how soon?
Hey, Seth, is there any way we can talk to the judge briefly?
I mean, she's in a settlement conference right now. And I don't know if she'll.
The reason is Lauren already filed this in the underlying case in Oakland County. It got granted. I just can't stipulate to dismissing, but we think it's going to get granted. If the judge just rules on the briefs, I'm okay with that. without having oral arguments, if Lauren is okay with that.
Thoughts?
I mean, if she's gonna grant it, I don't mind. If she's not, I need a record.
Right.
Oh.
And that's kind of why, if we could have like a phone conference with the judge in the next couple of days, or we could just set it and I'll come, whatever works. It's my fault, I apologize.
No, that's okay.
Lauren, I'm sorry, Zainab's last day was Friday, she went on maternity leave and Ali was supposed to cover, I didn't know.
And what kind of motion is it? Material misrepresentation?
Yeah.
Yeah,
She usually denies those, I'm gonna be honest.
Definitely gonna need a record.
Yeah.
All of the other ones granted. Will be my only.
Just.
Have any availability like tomorrow? I'm
Uh,
only thinking because I'm gonna be down here anyway. So instead of a completely separate day, midday,
2, 3.
the word here.
So
Yes, Judge.
they need a new MSD date. This joker who on the Zoom. And who said they waited for an hour on Zoom, nobody talked to them. Cause they weren't supposed to be on the Zoom, and then these people need a trial date.
Who is this, the other 9:30?
UAW. Okay, they need a trial date.
Okay.
So they need a new
Monday or
MSD
Wednesday?
date. They're not going to trial, I think. Y'all think y'all going to trial, y'all think y'all gonna settle, they kind of close.
We're very close. Okay, Wednesday.
They'll get a Wednesday.
You want a July or August?
August, nobody.
August, okay, sorry. Yeah.
So this makes sense.
Would you be able to come in tomorrow at all?
You will come back tomorrow?
You'll be here.
I'm in Marshall tomorrow, I can't,
You're where?
in Marshall.
Marshall.
They don't come. Thank God, that don't be negotiating with terrorists.
I'm back next Wednesday.
Next Wednesday, we have. Wednesday next week is terrible. We have 7 MSDs up that day. And she's gone next Tuesday. To reschedule all those. Next available might be 5th, is it too far?
I have maybe something. Then I am in the Board of Appeals.
Ooh. Okay. 2 or 3.
And then I started track.
Oh, man. May 13th. Also full.
I can make it work.
Are you gonna be down
No,
all the week after?
the week of the 18th or the 11th.
Week of the 18th, are you gonna be down here at all?
Nope. If there's other days sooner, I'd rather just.
13th. 13 or 14.
Um, 13 would be better.
Would May 13th work?
May 13th works.
Do you need a repress it here, just a renotice?
Just to renotice. We don't do press fees for the MSDs because I'm the guy. What did I say, 13th?
Yes.
I can, if you'd like, well, you have all your briefs in, so.
Yeah.
Just do a renotice. All right, May 13th, 10 a.m. in person.
Thank you.
Thanks, Kasim. Bye-bye.
All right, Lauren.
For 49 years.
49 years. All right. Could you advise the court of the educational, no, sorry, the healthcare institutions that you have been affiliated with and or worked at? And if you had worked in a supervisory capacity or a board capacity, please indicate that as well. Initially, when I first got into practice, I started training residents in the early 70s at the Kern Hospital in Northern Michigan. I was on the residency training committee. And I was on that committee for 15 years. Then I went on to peer review. And then I moved my practice from Madison Heights to Waterford. In 1983, I was asked to form or found a division of podiatric medicine at the then Biovascular Hospital. And I founded that division. I was the chief for 38 years, up until the time that I retired. We joined staff and formed that division in 1983. In 1999, I was asked to fund a residency training program. And we did all the paperwork.
At that same hospital?
That is a different hospital. That is, okay, let me go back. Mining Hospital was the hospital that initially became a member on Skyline Division for the medicine. That was in 1983. But in 1999, at that same institution, which was now renamed presently Clear Open Hospital, I was asked by the Dean of Graduate Studies if I would form the podiatric residency program. They have to be certified by the podiatric medical education. We did, and I did. When I did that, I became the clinical director, and I also founded an outpatient clinic to train the residents. And I was
I served in that capacity along with being the chief of the division for 20 years in the residency program. And when I retired, that's when I turned over the reins to a former resident.
And over those years, and I outlined previously, you taught residents at your institution throughout, right?
Yes, yes.
And
Journal clubs, setting up lectures, instructing interoperatively for pre-op, post-op.
yes. Did you teach clinically and didactically as a professor or anything of that nature?
Can you repeat the question?
Were you a professor?
I was an adjunct professor at Michigan State University College of Osteopathy. And I found that very enjoyable too. And didactically, I taught osteopathic residents in the clinic and podiatric residents who were on my residency training program. The osteopathic residents were on my program, but they used me as an elective.
You remain board certified throughout the time that you practiced. Is that correct?
Yes.
Are you still board certified?
I haven't done any cases, but I'm still a member of the board. I haven't done any cases because I'm retired.
Throughout the times at issue in this particular complaint that you review and review all the medical records in this case, you were board certified and actively practicing year prior to
Yes.
Did you, have you published any works that are related to the issues in this case?
Throughout the years, especially the early years, yes. When I retired, my chief president published an article in the American Medical Association Journal. It was a long time ago. It was from 2002. I don't really remember whether it was on. I recall it.
In your practice throughout the years, and mainly the year prior to this incident occurred, did you actually perform surgeries similar to the surgeries that discussed in this case?
Can you repeat that?
Okay. The year prior to the date of this incident, were you performing surgeries in your practice to similar or same types of patients?
Yes, are you talking about condition?
Yes.
The condition is.
Yes. All right. In what condition are you probably referring?
We're talking about hallux rigidus with degenerative joint disease, either from trauma or from a foot position is relatively rigid, placing additional weight load on the first metatarsal.
In this case, were you provided with medical records and documents that gave you information about Mr. Perez's care, and treatment, in particular management by Dr. Faye?
Yes.
You had complete information, able to give opinions in the case.
Yes, I was also relying on the position that he went to before Dr.
And Dr. Vopel was a orthopod.
Yes, right.
Or three position, right? Yes. And you're familiar with the surgeries and the condition and how it should be managed by a podiatric medicine specialist physician, correct?
Yes.
Have have you ever had a procedure, or a patient same or similar to Mr. Perez, requesting surgery on his, I refer to it as the big toe, for Howard's wishes?
Many times before you know this.
Have you done research and investigation of this condition with patients in the clinic with residents for teaching purposes?
Yes, we would have journal clubs, going to seminars, reading articles, and just knowing what works best, and what works least over a period of 41 years.
Your Honor, I offer Dr. Goldston as an expert in this case in the area of podiatric medicine.
Any more qualification?
Your Honor, I think that's the purpose of the hearing today, and I don't object to his.
But the purpose, but there's two different things. There's his qualifications as an expert and the admissibility of his opinions. Those are two separate things, are they?
Those are two separate things, but what I was trying to say is I don't object to him being an expert in podiatry.
Okay.
But I object to him being an expert in first MPJ surgeries utilizing a Cartiva implant.
Do you wish to order him as his educational background in China?
That, I don't need to provide him at this point.
Okay.
I wish to reserve that for my examination of the patient,
All right.
not my patient.
Okay. Your motion to qualify him as an expert for the purpose of this hearing is granted.
Thank you. Doctor, you indicated that you received all of the relevant records for Mr. Perez related to Dr. Faley's surgeries and others surrounding his management of that year prior and pre-surgery. Is that correct?
Yes.
All right. Could you just kind of explain what was the factual circumstance of this patient's presentation for the surgery and decision that has to be made with regard to what surgery?
Okay, can you be a little more granular? What exactly do you want to say?
Yes.
Or,
Give a synopsis of the circumstance that presented here that ended up in an injury.
is the patient's complaint and what procedures he had done?
Yes.
Oh, okay. That's what you. Well, the patient presented himself. I need to talk about Dr. Hotel first because that's part of it.
Yes, I think that's cool.
Yeah, he went to see a orthopedic surgeon. And Dr. Hotel did an examination. That would have been identical to the examination I did. And he recommended an arthrodesis, which is a fusion of a joint at the first metatarsal plane. He also recommended a lengthening of the gastrocnemius muscle, which is the muscle of the calf muscle. The reason why he recommended that is that he performed a test called the silver scoring test. And that measures the amount of plantar flexion or downward position of your foot towards the floor. The reason that that's important is because when you have this plantar flexion, the first metatarsal flange is brought into prominence and is overloaded by the patient's weight and excessive weight because of the malpositioning of the foot pointing down. This is one of the reasons that, one of the things that can cause callus rigidus is plantar flexion of the foot at the ankle. And evidently he had significant plantar flexion. Dr. Volkel examined him. Then he went to see Dr. Faley. And Dr. Faley did a similar examination, except he didn't find anything of significance when he did the same test, the silver scoring test. He didn't find any real deformity of significance. So he did not recommend a lengthening of the Strayer procedure, STRYER, Strayer procedure to lengthen the gastroc muscle and tendon. And the reason for that is that it would reduce the amount of plantar flexion in the load on the affected joint. He did recommend Dr. Faley an implant. I would have recommended an implant. Dr. Volkel recommended an arthrodesis, which is a fusion of the joint. I don't know if I would have gone that far to fuse a joint to get a stiff joint. If the surgery didn't work, maybe I'd consider an arthrodesis. But you know, you want to try to maintain joint function and also eliminate whatever the retrograde force is that could exacerbate a hallux rigidus problem, even pre-operatively, post-operatively, whatever. Now, Doctor selected a Cartiva implant.
I'm sorry, before you move on to the implant, you said the goal was to eliminate retrograde?
Yes.
Retrograde what?
Okay. The patient's foot was plantar flexed,
Okay.
like this.
Rigid.
Rigid.
Okay.
Yeah. And that's because the calf muscle, the gastrocnemius muscle, is tight and contracted.
Okay.
All right. So the gastrocnemius recession or lengthening eliminates this and allows this
With that flexion?
to decrease the load on the
On the
area of the
joint.
hallux rigidus.
Okay.
Yeah. And that was the reason I agreed on that. I wouldn't put the patient through an arthrodesis yet, but the implant that I would have used is a tried and true implant. And it's a wonderful implant. It's got all of the makings of a stable device that will allow bones to heal and it won't cause subsidence. Subsidence is a term that is used when an implant isn't stable. And the bone lysis, LYSIS, fragments, and also erodes. And where the implant sits within that concavity, the implant is going to move, it's going to displace. And there are other things that it does that we can get into later. But with the implant that I would have selected, we would not have had subsidence. We would have had a stable implant. And I wish we had a blackboard that I can illustrate that. I had drawings, but I wasn't possible.
Is it this? Couple spots, actually. Are you talking about drawings?
Yeah, the drawings that he did.
Oh, okay, yes, I got them, it's exhibit 7. Can I approach the witness, Your Honor, and show them exhibit 7? There's a few drawings that were made.
Oh, I've got it.
Yes.
Is this what you got?
Yes,
Okay, yeah, I got it. I mean, I can use it for everybody to see.
Mr. Different exhibit 7 than I have, right?
Right,
In this book.
I think it's in the binder, Your Honor, it's exhibit 10, or sorry, it's exhibit 18, it's the same drawing. And exhibit 18 is actually, it's marked from his deposition, there's a sticker on it.
Oh, I see.
Upper corner.
yes.
It looks like this.
Is it exhibit 8?
No, in the binder that I gave.
No, I mean, that.
I just want to
It's
find
exhibit
the-
8.
It's 18.
8?
8, I've got 8.
Okay, but here's the thing.
Then I don't know.
I got exhibit tabs. Can somebody help me? I have exhibit
That's from his
tabs.
deposition.
And
not-
under
yeah,
the-
that's like-
I have exhibit tabs in this binder.
Yes.
And under, they're numbered, but under the numbers, there's letters.
Oh, yeah.
So that's because they were attached to motions for some, I know, Your Honor, my office, I put it together, makes it a little confusing. But
So I just want to know where I can find the picture that the doctor has, so I can go along with it.
It's in the binder and on my exhibit list, it's 18.
Like this binder. It's broke. Doctor, is it this right here?
It's a,
Okay.
I mean, you're.
It's
it
another
may be-
version
It may
of
be
it?
out of order.
Okay. But these are your notes?
Yes.
Okay. I got it. All right.
All right, can I stand when I do this?
Yeah, you can do whatever you want.
You had some, sketches or drawing, to supplement the information you were providing to explain the procedures, and implants that, how they would, impact the joint.
Oh, yes, you're talking about that extension that goes into the joint, and you're talking about that double spin.
Yes.
Yeah, I've got it here.
Okay.
Yeah, I've got it here. But if you can give me that, that printed picture, that could also supplement what I'm going to do.
Be careful, doctor.
Thank you.
Doesn't make any difference where it's from.
No?
All
As
right,
long as
you
I
know,
can hear you,
I'm
you're
in
good.
I'm in my realm right now, which is education. Okay, so I'm gonna forget, that we're adversarial and you the judge and he's our attorney. And I'm gonna lecture, and I'm not gonna be dictatorial. I'm just gonna go ahead and lecture.
This is my.
Shall I proceed?
I don't know, I think we gotta wait for them.
Okay.
Point of clarification, just so we're talking about the same stuff. I filed a witness, or not a witness, an exhibit list concerning this hearing today. And I delivered a copy of these exhibits exactly as they are in the list in Mr. Watkins' office. And he's here today with a different binder with different exhibits and different numbers than what I filed with the court and delivered
Let's
to
just
council.
get everybody on the same page.
Exactly.
I provided them with a copy of my binder with my
It's okay,
exhibits as
it
well.
doesn't matter.
Okay.
Let's just take a moment and make sure everybody knows what pictures, what images are about to be used.
Right.
Yeah, I have them in my binder, which is. the
Probably
sticky
has
notes.
different numbers too.
Probably, but they're
So
there.
let's just take a moment and make sure everybody's on the same page, okay? Are you saying you don't have that? Okay, well, let's get a copy made for you, okay? Well, it's not readily available, and that's easily remedied because we have a copy machine.
This is the water.
So if you hand it to the court officer,
Is this, that's yours?
the court officer will take it in the back and make a copy.
Yes.
I think it's okay. Yeah. I'm sorry. That's all right.
Is that the only thing we need to copy?
Well, he won't
I don't
know
have
until
anything
you
in
pull
your
something
report.
out that he don't have.
I don't have anything that says.
No, that's not true.
Gentlemen, let's not quarrel over it, okay?
We're just trying to figure it out. Your
I
Honor.
know.
Yeah, not actually fighting, just, I think the issue is, I'm not saying I never received any of these.
You just don't have it handy
I
right
wasn't,
now.
yeah, I wasn't aware he was using these exhibits.
Okay, so here's what we're gonna do. We're gonna take a moment
I can't talk.
for you to go through it and make sure you have it. It'll take about 5 minutes, okay?
Okay, that's very good.
I would say, if you could just tell me on this, which one's yours, if it's okay, then I can look and see. Because I know I don't have. I'm not saying I never received it in the past. I'm just saying I didn't know you were using it. I haven't had that, that's like I said, my exhibit. Yeah, exactly, the your exhibit too, yeah.
They were self-centered.
Okay, anything else? Because I'm, like, this is all stuff that is attached to your, some of it's in my exhibits. Let me see what's the- Piece of paper and organization, right?
Yeah, I could,
Who's on first?
in my profession, everything is, with your hands. And, there wasn't much deviation. You guys really, I mean, there's an art to what you do.
Are you using any of the literature you were attached to your responses? All the literature. Because if you are, I have.
Okay. I mean, I don't know how we.
I'm not saying you do it.
Bringing
I
this
just wanted to.
us back at the same time.
I expect that it's gonna be on the record.
Yeah, I mean, Carlos been found before.
Oh, I said, son, can I take your pen?
Oh, thank you.
Okay.
Relative.
You would never. No, I would never.
Literature in my mind here, there's all these, that you attached to your, all these letters here. So if you're using any of those, then I have. All right, I'm just trying, yeah. But if you can just tell me, like, when you're, where you're pulling it from, just so I know, are you getting this from mine or from yours? From yours? I have your list, but I don't have the binder. So it's the letter, we should take those out. That's just because that's what they were to the most dispositive motions. Right. So, yeah, a little confusing.
Good morning, Judge Lillard. Well, what's the question?
This is what they probably have. Just that.
At the same time? You only have the press meeting because I haven't gotten to the. What's your concern? Hello? Hello? No worries. What's your case?
Everything he says.
Okay, so you'll just need to file a notice of appointment for the motion for the, because it will now be heard on the same day as your next week, April 22nd. Okay, and thank you for calling.
So you don't have a copy of this for him. My. I just asked, so if I ask him a question, you have a copy of that.
Well, I mean, you can just kind of give it to me.
Yeah.
That's the extra copy.
We'll figure it out.
I believe it's.
You know, last trial I was in, I had so many copies of exhibits, and we used none.
Yes.
Boxes.
Everything drops down to a rote memory by the time you just try.
Thousands of pages of.
I'm tracking this off at your office, and I don't want to see it anymore.
Unfortunately, yeah. Depending where this case goes. I don't know.
No, we just had a pre-chat conference.
Oh, yeah. You still
Y'all ready?
Yes.
Got everything?
I'm sorry. As far as I can tell, Your Honor, yeah, we compared. I didn't have this page with me. I should have it.
It's okay. All right, whenever you're ready, you may proceed with your questioning on the witness.
What?
It's up to you and him.
Okay, understand. You're good, right there. Okay. Yeah, right, on that. Yeah, when I'm ready.
I'm ready whenever y'all ready.
So, Doctor, you can proceed with your explanation of the procedures offered under the circumstances and how they impact a patient like this, and how the physician responsible, Dr. Fagan, should have evaluated and applied this information.
Okay. Within the, really everything that I'm saying is within the community of podiatric physicians, surgeons. Similar training, similar education, similar seminars, similar residency programs. We all fall within with an average all around, knowing commonalities in different conditions in special. So not that I'm speaking for any individual podiatrist, but I'm speaking for the community of podiatrists.
Okay,
Okay. Well,
so are we gonna talk about, are we talking about this picture or,
I'm talking about pictures and images.
okay,
Okay. The first thing that I want to talk to you about is the anatomy of a metatarsal bone.
okay.
In the metatarsal, there are 5 metatarsal bones. And the
And
first
for the record, I believe he's holding up what's been marked as exhibit 8.
Yeah,
But it's in the binder, it's in defendant's binder as exhibit 18, but it has a sticker on it that says exhibit 8
And that's
what it says.
from his
That's
deposition.
his deposition.
Yeah,
Too many exhibits.
I just want the record to reflect what he's showing me and what I'm looking at, that's all.
Okay.
Okay.
I'm gonna, I don't want to insult your intelligence, but I do want to
You won't.
educate you.
You
Thank you
won't.
very much.
You saw my intelligence.
This is the first metatarsal.
Okay,
This is the metatarsal bone. And this is the metatarsal head.
okay,
Here. This is the actual body of the bone. And this is the base of the bone.
okay.
Simple. Okay. Now we'll get into a little more detail. I think the issue, there are 3 issues to the outcome of this case. One issue is the consideration of bone density. The other issue is the consideration of the selection of an implant that will enable the bone to heal and seal around the implant so the implant doesn't migrate. Because that implant has extensions that go into the first metatarsal flange joint, and it opens up that joint, allowing free motion in that joint. The second thing, or the third thing that I think is an issue, is that we have to remove the deforming force of the plantar flexure. In other words, if the foot is pointed down and the patient has a silver scoring test that makes it justifiable to perform a gastric medius recession, lengthening that and bringing the foot out of plantar flexion into dorsiflexion. That's ideal because what that does is that enables the success rate of this type of procedure to be more than likely. More than likely. We're removing the deforming force. Okay. This is the metatarsal bone, and this is really important.
Okay, so for the record, we've moved on, the witness is showing me the next page, page 2 of exhibit 8. For the record, I just want the record to be clear what the witness is using.
The first layer of bone is cartilage. Cartilage is hard. The second layer of bone beneath the cartilage is subchondral bone. That bone's hard too. But where you have the fanning out over here, the head of the first metatarsal, that's called the metaphysis. And the metaphysis consists of soft bone, bone that isn't dense. The shaft of the metatarsal bone is called the diaphysis. The diaphysis consists of highly dense bone, hard bone. And then the base is also cartilage and subchondral bone. But we're really not worried about the base. There's nothing back down there. What we're worried about, what we're concerned about, is the head and the neck. Okay. Let's see what that one there. Okay.
All right, I just, you gotta ask a question, you can't just narrate.
Am I doing anything wrong?
Okay. You need to, do you need to further explain the anatomical structure and how the decision on the implant would apply under the circumstances.
It's coming up.
Okay.
All right, okay, that's coming up. Okay, I'm going to use an implant, I'm going to show you an implant. That is the implant that I use. It is an extremely stable implant. Tried and true. It's called the double stent scholastic implant.
Okay, are we moving on to another?
I am moving, this is page 4.
Okay.
Okay, this is page 4. Now, as you can see,
That's an implant widely used.
this is the implant that I
That
use.
she believes would have been appropriate for
That's
this
right.
patient's condition,
Yeah,
correct?
Yes.
Okay, so it has a stem. It goes into the toe, the bone in the toe. And it has a stem, it's a double stem, it's stem. It goes into the metaphysis down to the base of the metaphysis over there. The other thing that I like about this, and I'll tell you why I like this, is that there is like a cushiony spacer. And this spacer keeps the joint open post-operatively and gives it its flexibility. That's the whole idea of the procedure. So if you drill the bone, do a pilot hole and put this stem in here, do the same thing in the toe, put the shorter stem in the toe, then position this spacer into the metatarsal phalangeal joint. Now you have an open joint that is not restricted by a joint collapsing. And this is what happens with the Cartiva implant.
It collapses.
Yes, I'll show you how. But what this does is that stability is very important. If you don't have stability in an implant, the implant's going to move. It's going to migrate. Now, when it moves, that interrupts the normal osseous healing process of bone healing in fibrous tissue that hold the total implant in. And what happens if you don't have stability, and I'll show you why. If you don't have stability, you have lysis of bone, which is disintegration of bone. You have erosion of bone, and the implant just does not sit properly. This implant, if done properly, and of course it is, offers the most stability and the most predictable outcomes.
And what's the name of that implant?
It's a Swanson double stem scholastic first metatarsal phalangeal joint. It's on the implant. It's on the picture. I have on the picture.
Could you juxtapose an explanation of the anatomical application of the Cartiva implant
Well, I'm going to
and
do
how
that.
it doesn't
Yeah, I'm going to do that.
provide?
Yeah, I thought that I would use this first. So these stems provide stability. And this cushiony area opens the joint as a spacer and allows the big toe to dorsiflex or move upward, downward, no pain. Okay. The Cartiva implant is a little different. I describe it, to me, it looks like a space capsule. It needs a parachute. It actually is like a bullet. And the way it's used is that a hole is drilled into the metatarsal bone. And with your finger or thumb, you press this implant into the hole that you've created. All right. There is nothing on the surface of the implant that would give it the stability that this implant has.
Because it doesn't have the cushion.
Well, I'm gonna get to that in a minute, but it doesn't have the stability, because it doesn't have it doesn't have these, hinges, actually not a hinge, but they're like, they're like little rods. That causes the stability, so it doesn't move back and forth. The cushion that you're talking about is what opens up the joint and keeps it open. And postoperatively, it doesn't have to be a complication you need to worry about, and it makes the outcome more predictable, weighted in favor of this implant. Now, we'll get to the Cartesian implant. This is a Cartesian implant. It's smooth. It looks kind of like a bullet.
And for the record, he is now using page 3
Yes.
of the deposition exhibit.
So as you can see, there are no extensions going proximal or this way. There are no extensions going this way. And I'm not going to alter this because I forgot to put this on this for the deposition. I want to show you the difference. Here is the double stem implant. Here's one stem, another stem, stability, open the joint,
Doctor,
spacer.
has this drawing been marked as an exhibit?
No, because I just drew it.
So we're gonna need to mark this, so the record comes that.
Now, this is the Cartesian. Just a second. Okay, let's mark, I think there's another picture too there. Mark, exhibits A and B for the hearing would be drawings that the doctor is describing. Drawings of the implants. Holes. And also this. All right. These are drawings that will be added to exhibits. But for the hearing, it'll be A, B, and C.
Okay.
Okay. So if we compare these side by side, I'm sure
Are
you
you
remember
doing
what
page
this
3
is.
and page 4?
Mhm. Yes. There is no stem going proximal, no stem proximal, and there's no stem going into the toe. Stem, stability, doesn't move. Now, this is interesting. And I'm using another, I don't want to deface any of these exhibits. But the Cartesian implant has a 2 millimeter spacer. The 2 millimeter spacer is part of the implant. And when the implant is put in properly, this spacer goes into the joint and it keeps the joint open. Just like this keeps the joint open. But what is more stable? The horizontal spacer in the joint, or a 2 millimeter spike. It protrudes in the joint and is supposed to keep the joint open. Could you explain why the reason for the prudent diatrist
should anticipate or recognize the risk of sinking or in that area.
Yes, I wanted to go ahead and explain what happens to this. Our people do.
Pointedly is that bone softer than the rest of the toe, or
Where the implant then is metabolism, that bone is less dense and soft.
it is something.
Yeah, that's one of the reasons why we, well, I should tell you. Yes, that's one of the reasons why we.
No, I want you to explain that. Pardon? No.
Was your honors?
Oh,
No, I'm ready.
Oh, you want? Oh,
Yeah, I'm
okay.
taking notes.
Oh, gee, I didn't know, I'm sorry. I'm
Yeah.
sorry, okay, all right. Now, there is an extension of 2 millimeters
That's supposed to keep the
of the
joint
cartilage,
open.
yes,
Yeah, I
of the
wrote that down.
cartilage implant, right. But where are you going to get more stability when you have not only these extensions, but you have this? It isn't a peak, it's not a peak, it's not an apex. It's horizontal and it fits over the total surface of both bones, both the toe and the metatarsal. But
So the captiva does not provide any cushion at the metatarsal.
it doesn't provide cushion. It also doesn't provide stability, and here's what happens. Okay. The implant, because it is not a stable implant, at least the implant at the time before it was recalled, because it was recalled and it went back on the market. I have no idea when it went back on the market. I didn't read any literature about that. I just know that at this point in time, it wasn't recalled yet. And so what happens is that because there are no safety features, the stems, the double stems, there are no safety features, and because this bone is soft, the implant is going to migrate down. And bone surrounding the implant will become lytic, Lytic, lytic. It'll crumble, it'll erode, and the joint, and the implant will just move. It could rotate laterally to the right, to the left, it could piston up or down, it could go towards the joint, but most of the time, it goes more proximally down the bone towards the shaft of the bone. This is called subsidence. Subsidence is when you don't have, when an implant does not provide enough stability, and it moves and wiggles and jiggles, and the bone never has the ability to heal around it, to seal around it, and the implant just displaces. When that happens, and this is real important, that spacer, that little 2 millimeter spike, that will go down that metatarsal bone with the rest of the implant. And so now there's nothing spacing it. The joint collapses on itself, and we're right back where we were before. No joint space, which is the goal of this particular, one of the goals of this particular procedure. And now it's bone on bone again.
Now, for this patient, was there another reason why a prudent podiatrist should have steered away from offering this procedure with regard to his pre-existing condition regarding
I know. All of us community of podiatrists, USA, Midwest, Michigan region planner. As I said before, we have a commonality of the way we think, because that was the way we learned. We learned the scientific method and evidence-based medicine and surgery when we were in podiatric medical school, residency, going to seminars, and sometimes even anecdotal, because you see what works and what doesn't work. It takes a lot of experience. So it's a combination of all those things. And so I've always taught my residents, stability is the first thing that you have to consider in an implant. Because if you don't have stability, the implant's going to fail. Then the proper choice of implant, the one that offers stability, the one that offers a consistent and all around predictable outcome, such as the double stem scholastic implant. The Cartiva implant, I didn't like because it didn't have the extensions in the toe, down the metatarsal bone. It lacked stability, and I knew if this thing would move down the metatarsal bone, that the peak, this little 2 millimeter peak, would just disappear, and now the bone's going to collapse on itself. So I think, not that I think, but I can't speak for 100% of the population of podiatrists. I can only speak for a commonality, and stability and choice of implant is key. And we all know it works, but it doesn't work. Also, the other portion of the procedure that I think was necessary was the Strayer recession of the gastrocnemius.
The capitalism
Capitalism.
to create more flexibility.
Yeah, to decrease the plantar flexion, increase the dorsiflexion, and you don't have that force going on the artificial joint.
Now,
So
he asked
that's
you a
what-
question. Was there another condition that this particular patient had that made the Captiva not an ideal implant for him? And I'm not sure you ever answered that question.
I'm going to answer that question. Can you repeat?
You asked if this patient, was there, in addition to the lack of stability of the Captiva, if the patient had an additional condition that made the Captiva not an ideal implant to use.
Oh, yes.
Correct? Didn't you-
Yes,
didn't
yes,
you know what
yes,
you
yes,
said?
yes. And that would have been the plantar flexion. That would, the Cartiva, wouldn't work if it was plantar flexion, because there's more pressure being placed where the implant is. And if the implant wasn't stable and it wiggled and jiggled and moved all over the place, well, that's no good either.
So by there being more, we'll start that, with the plantar flexion still there and unaddressed as it was left by Dr. Fagan, did that put more pressure on the joint and increase the likelihood and the rapidity that the implant would fail?
The plantar flexion of the foot is what put all of that conforming weight to bear on the first metatarsal flange joint. So to answer your question, that implant wasn't good because if it doesn't have the stability, then that deforming force from the plantar flexion is going to make that joint or that lack of joint more unstable because the implant is unstable. Because the implant can't defeat, you can't withstand The deforming plantar flexion course will force new plantar flexion. I hope that answers your question.
I'll follow up a little bit. Some, if there's been studies now, and they found that it was effective and recalled it, but the implant itself, over time, it showed a large number of those cartivas sinking and therefore failing, correct?
Okay, all right.
Objection, Your Honor.
Hold on, there's an objection.
Just objection to the leading nature of the question.
Well, I think he's just overruled, because I think he's simply restating something that Dr. had already said.
Yeah, I mean, that's what I'm doing. So I just want to just clarify.
Well, no, because if there's an objection,
Okay.
and then I rule, then that's that. So if you don't, did you understand the question?
I think I did, but I'm not 100% sure. I have different
Repeat
ways.
the question.
In this case, all right, the patient was offered a Cartiva implant, right? And you've already talked about how the implants, whether it's the better model that you recommend, the stabilizers, or the Cartiva, they're in soft bone, right? And that puts them at risk for sinking, right? Or failing. Yes, right? But some of them don't fail, right? And the risk of failing, which a reasonably prudent podiatrist has to consider before offering it under these circumstances, they have to consider other conditions that may be impacting that joint and may cause the implant to fail as well, right? All right. So the fact that this patient had a plantar flex, which was not addressed at all by Dr. Fairley, did that put the patient at higher risk for the implant failing because of this instability, soft bone, and the fact that it puts pressure on that joint in a more stronger emphasis to a point where it
Yes,
fail
it
faster.
does. Yes, it does. And if the Swanson skin implant would have been used, then there would have been more stability, and there would have been a joint space. So the implant wasn't stable to begin with. You get that deforming force from the plantar flexion, and that was just one of the other things that just caused the instability to get worse.
And one of your criticisms in the case was a failure to address the plantar flex.
Yes. Yes.
Strikers, yes, correct?
Yes.
Was it a deviation in the standard of care by Dr. Fairley about offering a Cartiva implant in this case, and under the circumstances and the condition that this patient was in?
Based on what he learned in his studies, going to seminars, residency programs, because I know how these work, because I had a residency program for 20 years. And what you learn that if you don't have a stable implant, and you have, in addition to that, a plantar flexed foot that is putting pressure on an unstable implant, I wouldn't use that. the normal, regular, prudent podiatrist with similar education, as I'm standing here today, would have gone with a more stable implant, double stem implant. So that's my answer.
So the standard of care would have required him to use either a more stable implant such as the double bridge stabilizer.
The Swanson double
Swanson.
stem implant.
Swanson. It would have been within the standard of care to use a implant like the Swanson or one with similar stabilization.
Yes.
Standard of care did also require that he address the strider with their striders.
Yes.
Okay. He failed to do that.
Yes. That's right.
Your opinion is also reliant upon your experience, training, and specific background over the years. Is that correct?
Yes.
And you in fact had performed investigative or testing type procedures in the clinic or in the hospital with residents to talk about procedures like this and this anatomy of soft bone and potential use of implants.
We would do it two ways. Either we would do it in the clinic, in the journal, or we would do it early in the morning prior to starting surgery at a pre-op conference. And so I addressed it both ways. The residents were well informed and they knew what I preferred. They also knew from what they've learned at school and in the residency program too. And they all know that this is a standard of care. Stability.
You made your drawings, we've marked them as exhibits and support has been provided with copies that will be supplemented.
I have them here.
You indicated early on that there was another professional involved in the case before it went to Dr. Fay.
Yes, Dr. Lopez.
Yeah, Dr. Lopel was the podiatrist.
Dr.
He's not a podiatrist, he's an orthopedic
surgeon.
Orthopedic. And the implant as anticipated and the patient was factually set up for failure of the implant, did that in fact come into play?
Yeah, it came into play. Dr. Lopel did recommend a standard care procedure or procedures. Now, he did an arthrodesis, which is a fusion of a joint. I don't like destroying a joint. I like making a joint. And I would have tried the implant first. And I would have selected the one we used. And I would say that his choice of doing or not doing the gastroc or the Strayer procedure, the gastroc resection, I believe he was well within the standard of care because it would have been my standard of care. And I'm not an orthopedic surgeon. And my comrade in podiatry just went against it.
All right, we can try to wrap up. The implant failed, that Dr. Phelan put in for Mr. Perez, is that correct? Yes. All right. And it failed because of the issues that you outlined with the weaknesses of use of that implant in this case. Yes, correct. And the weakness of that implant as it applies to this anatomy with this type of condition. Yes. In the patient. Yeah. Yes. Exacerbated by the plantar flex that wasn't addressed by the
Also, I might have just added that the plantar flex, the contracted patents, gastric meniscus, can also be an etiological positive feature in the cause of the habit surgeries. So if you don't remove it, it's only force. What good is it correct?
It's a virtual setup for failure, particularly a defective type of implant, as you suggested.
It's an inconvenient truth.
You often indicated from time to time, you salted in what you would do under circumstances, and this is what I would do. When you were stating that, were you indicating what a reasonable podiatrist of ordinary learning judgment skill would do under circumstances?
Yes, same to similar education in terms of pediatric medical school, residency, thread, going to seminars. We all have a commonality in what we know. And in this case, commonality was the plantar flex, first metatarsal foot, and the choice of implants. Now, I know it was recalled, there have been some changes. I don't know what the changes are, but those changes were not available at the time that we had saw those. But we were working on it, and they wanted to know the results. And it's saw those, and I didn't like it.
A podiatrist can use various types of implants when they offer and consent them to the patient. Yes, right. Yes. They just have to be reasonably prudent in their selection and offering of those.
I always told my residents, all things considered, you have to consider it and make the accommodation.
But the implant was particularly inappropriate for this patient because of his existing anatomy that was not addressed at all by him before providing the implant.
This is true, but the implant had a high failure rate. One study that I reviewed had an 85% failure rate after a certain period of time. Another study that I reviewed had a 50% failure rate. And the patients didn't necessarily have to have the contraction in the gastric meniscus and the plantar flexion. This implant was used in all kinds of patients with that condition, without that condition, and it still failed because it was unstable.
As you explained, it's unstable from the outset, and under those circumstances, a large group of podiatrists agree that it's not an appropriate decision to the hospital.
Yeah, it was interesting because after I decided I didn't think it was a good implant, I don't remember any podiatrist on the staff using it. I told the residents that it's up to the podiatrist, the surgeon, he wants to use it. It's his option. I don't remember anybody really using it. Now, that was at the hospital, right there. But that doesn't mean that it wasn't. Maybe some of these were successful. But these were successful, not many.
But the kicker in this case is that he had the previous pre-surgical anatomy that should have guided any prudent podiatrist to realize that it's too high of a risk of failure. It's been exacerbated or supercharged by the fact that you're not even going to address the gastrointestinal.
It's as I said,
Or
that deformity is was an inconvenient truth. Yet he was not ready to perform that procedure. He was not going to was.
All right, Mr. White, because normally my staff takes their lunch break at 12:30. I was trying to give you some leeway to finish up direct, so they could go to lunch, we could come back and do cross. But you're kind of,
no, I'm
right now, I feel like, because he said that at least 3 times, I wrote it down.
okay.
So I'm not cutting you off, you have more direct. I will let you resume your direct when we return from lunch in 1 hour. I'll see you guys back at 1:38.
Thank you, Your Honor. Thank you.
Can we just move our stuff?
You can, nobody will be in here, the door will be locked.
I'm gonna do things.
Far from
All right, we'll be in recess for 1 hour.